Next thing we talked about was the burdens, the question of whose job is it? And we have several kinds of burdens or burdens that come in at different stages, of the lawsuit. So you can ask, who has the burden of raising an issue in order for it to be present in the litigation? That's the burden of pleading, and you saw that with Jones v. Bach. Is it the prisoner's responsibility to assert that he has gone through all of the required administrative appeals process before filing suit in federal court? Or is it the jail's burden to assert that the prisoner has failed to do that and therefore doesn't belong in federal court? Somebody has to bring it to the judge's attention. Who is that? And note this, if we say that it's the jail's burden and the jail doesn't think that the prisoner has failed to go through the administrative process, why doesn't the jail still need to plead that in its answer? Why doesn't it need to say, we agree that the prisoner has gone through the whole administrative process that he needs to and exhausted his administrative remedies before filing suit in federal court? Well, that's because if they agree on that topic, then there's no reason for the trial judge to even know about it. It doesn't need to be brought to the judge's attention because it's not a dispute that the court will be resolving. In fact, courts love it when there's no dispute because it simplifies the total range of things that the court needs to decide. So if everybody's agreed that the prisoner has exhausted administrative remedies, great. We never need to raise it at all, and we can keep going to find the issues that we do disagree on. Another kind of burden is the burden of production. Who has to produce evidence? So here's evidence that X happened, or sometimes here's evidence that X didn't happen. Note that here we're already often going to be assuming that it's the plaintiff who needs to produce evidence in order to overcome that default of no liability for the defendant. But it's not always going to be the case. You want to see how the burdens are allocated in a particular situation. And finally, we talk about the burden of persuasion, so persuading the fact finder that there's enough evidence of some event by a preponderance of the evidence. Finally, we talked about Rule 11, which governs all statements made to the court in litigation, and that means pleadings and all other papers. It applies at all stages of the lawsuit, and although usually it is attorneys who get sanctioned under Rule 11, it can also be the law firm or even a party if the party is responsible for the violation. So Rule 11 covers several types of bad acts, making a statement with an improper purpose. So if you make a representation to the court in order to harass or delay or increase the litigation costs, you're liable for sanctions. Making unwarranted legal contention. If you know that your legal assertion is incorrect, that is sanctionable. So what constitutes a warranted legal contention? Well, either your contention has to be correct under current law, or there has to be a non-frivolous argument for extending or modifying or reversing that current law. And we saw that in Haddle, right? In Haddle, the circuit law was very clear that Section 1985 did not count an interest in one's job as a form of property. And so existing law did not warrant Haddle's contention that his interest in his continued employment was a form of a property interest. But that was okay because he had a non-frivolous argument for changing that. And the non-frivolous argument there was not only the words of the statute, but also the fact that other circuits did not share this interpretation. So Haddle's lawyer, even if he had lost at the Supreme Court, or if the Supreme Court had not granted cert in that case, would not really have been eligible for sanctions, would not have been sanctionable, because he had a non-frivolous argument for his contention, even though it wasn't supported by existing law. So similarly, unsupported factual contentions, i.e. Lying or making stuff up, is sanctionable. So you have to have support in evidence or investigation that you have done, or it has to be likely that you will find support after further investigation. So you are allowed to, for instance, plead stuff on information and belief if you have a reason to believe that you will find evidence to support that statement. And similarly, the inverse, unwarranted denials of factual contentions. So if you say, no, that didn't happen, without any evidence to support or a reasonable belief to support your denial, that's sanctionable. You are, again, allowed to plead on information or belief, and you are allowed to say, I lack the information to respond to that, so I don't admit or deny. But you have to be clear about what you're doing, and you may not simply deny a factual allegation because you feel like it. Finally, Rule 11 applies to defenses as well as claims. That's kind of implicit in the way I was just describing it in the previous slide. But basically, the important thing to remember is that all written submissions to the court are subject to Rule 11 sanctions, as well as any later argument made in support of something in those papers. So if I say something to the court now that I believe or have good reason to believe is true, and then I realize that it's wrong, I may not then continue to assert that thing to the court once I have realized that it is incorrect. At that point, I become subject to Rule 11 sanctions.